I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. The topic for the day is right to privacy vis-a-vis technological advancement. The more technology we bring into our lives, the more our privacy seems to slip away. Introducing the topic, humans are considered to be autonomous beings with a natural need to have control and confidentiality in certain aspects of their lives. This inherent and inalienable need for privacy in human behavior is now recognized as a fundamental human right. Each person's privacy is an intrinsic part of their life and liberty and therefore required to be protected. The necessity of this right to privacy has been recognized by scholars and judges from time to time, and now it holds an irreplaceable position in the modern life. Even in India, the right to privacy is not explicit in the constitution of a country, but was brought under the purview of fundamental rights by the instrument of judicial interpretation. But with the evolution of society, the modern enterprises have unearthed many objects which led to invasion of privacy. The present time is an era of information technology. With the evolution of internet and its extension in accessibility, a new world with better communication, faster information sharing and more transparency has come into being. But everything has its own pros and cons. With the rapid technological advancement, there is also an increase in its misuse, which is largely inevitable and is further added on by the expanding use of the internet for exchange of sensitive, private and commercial information. Privacy cannot always be absolute and comes with certain limitations. Several laws have been made by the concerned state authorities to protect the privacy of their subjects, but these safeguards are not absolute and are limited by government in certain matters. But as more data is being digitized and more information is exchanged online, more importance is being attached to privacy. Data has to be regulated according to its perceived significance, as people have a lot at stake when it comes to the privacy of their information. Digital footprints are all over the place. Each time one visits a website, enters personal information, credit or debit card information, sign up for an account, deliver email, fill out online forms, post on social media or store images or documents in cloud storage, one releases personal information into cyberspace. Right to privacy, its meaning. Privacy is a fundamental human right recognized in the UN Declaration of Human Rights, the International Covenant on Civil and Political Rights and in many other international and regional treaties. Privacy underpins human dignity and other key values such as freedom of association and freedom of speech. It has become one of the most important human rights issue of the modern age. Privacy protects human dignity and other values such as freedom of association and freedom of speech. It has become one of the most important human rights of modern age. It can be divided into the following facets: information privacy, which involves the establishment of rules governing the collection and handling of personal data such as credit information and medical records. Bodily privacy, which concerns the protection of people's physical selves against invasive procedures such as drug testing and cavity searches. Privacy of communications, which cover the security and privacy of mail, telephones, email and other form of communication, and territorial privacy, which concerns the setting of limits or intrusion into the domestic and other environments such as the workplace or public space. Discussing the right to privacy around the globe. Privacy can be defined as a fundamental human right. The law of privacy can be traced as far back as 1361, when the Justice of the Peace Act in England provided for the arrest of peeping toms and eavesdroppers. In 1765, British Lord Camden, striking down a warrant to enter a house and seize papers, wrote, "We can safely say there is no law in this country to justify the defendant in what they have done. If there was, it would destroy all the comforts of society, for papers are often the dearest property any man can have." Parliamentarian William Pitt wrote, "The poorest man may in his cottage bid defiance to all the force of the crown. It may be frail, its roof may shake, the wind may blow through it, the storms may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement." Various countries developed specific protection for privacy in the centuries that followed. In 1776, the Swedish Parliament enacted the Access to Public Record Act, which required that all government held information be used for legitimate purposes. In 1792, the Declaration of Rights of Man and the Citizen declared that the private property is inviolable and sacred. France prohibited the publication of private facts and set stiff fines in 1858. In 1890, American lawyers Samuel Warren and Louis Brandeis wrote a seminal piece on the right to privacy as a tort action, describing privacy as a right to be left alone. Coming to international instruments on right to privacy. Numerous international human rights covenants gives specific reference to privacy as a right. The International Covenant on Civil and Political Rights, the UN Convention on Migrant Worker, and the UN Convention on Protection of Child adopt the same language. The modern privacy benchmark at an international level can be found in the Universal Declaration of Human Rights, which specifically protected territorial and communications privacy. Article 12 states, "No one should be subjected to arbitrary interference with his privacy, family, home or correspondence, nor to attack on his honor or reputation. Everyone has the right to the protection of law against such interference or attacks." International Covenant of Civil and Political Rights, for which India is a party. Its Article 17 states that no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home and correspondence, nor to unlawful attack on his honor and reputation. Next is European Convention on Human Rights, and its Article 8 states that everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety or the economic well-being of the country, for the protection of health or morals, or for the protection of the rights and freedom of others. Now, coming to right to privacy online. Many people do not understand privacy and some even dispute its very existence. There is a sense of being under a perpetual state of surveillance or fear of losing privacy as an increasing number of people come online. Browsing the internet, posting on a friend's wall, tweeting, uploading pictures, shopping and watching videos online all leave traces of data everywhere. Although the usage of personal detail for internet services present risks that just now become apparent. Such threats arise from private and also from public bodies. In 2012, the United Nations Human Rights Council affirmed that freedom of expression on internet is a basic human right, which implies that the right of an individual existing offline must also be protected online. UN Human Rights Council first resolution on internet free speech states as follows. The resolution affirms that the same right that people have offline must also be protected online, in particular freedom of expression, which is applicable regardless of frontiers and through any media of one's choice, in accordance with Article 19 of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, and recognizes the global and open nature of the Internet as a driving force in accelerating progress towards the development in various forms. The Internet and digital technologies today provide tremendous utility for our daily lives. With time, our dependence on them will only grow. There is a need to keep the personal data that is collected from each person by such services. This can, to a large measure, be implemented by secure communications. In many countries, the concept has been fused with data protection, which interpret privacy in terms of management of personal information. Outside this, in rather strict context, privacy protection is frequently seen as a way of drawing the line at how far society can intrude into a person's affair. The lack of a single definition should not imply that the issue lacks importance. Ability for others to access and link the databases with few control on how they use, share or exploit the information makes individual control over information about oneself more difficult than ever before. Now discussing impact of technology on privacy. Digital era privacy rights are deeply impacted by modern technology, which has a far-reaching effect on people's life, community and the larger human interaction environment. This effect can be viewed from a variety of angles, taking into account both advantages and disadvantages. Now discussing what are the favorable effects. It is enhanced connectivity and communication. The advent of new technologies has made it possible to connect and communicate at previously unheard of levels, which has promoted international cooperation and information sharing. While increasing connectedness, foster better social interactions and knowledge exchange, it also makes appropriate data management necessary to shield people's privacy against invasions. Technological safety measures. Personal information is protected by advances in cyber security and encryption technologies, which also give people the means to secure their digital identities and conversation. These technologies are essential for protecting sensitive data integrity and confidentiality. Technological developments that provides privacy challenge also give rise to creative solutions in the field of privacy protection. Differential privacy and decentralized systems are examples of privacy preserving technologies that attempt to balance the need for personal data protection with the advancement of technology. Empowerment via control. Thanks to some technology, people have more influence over how they appear online. User can choose who can access their information and how visible it is on social media platform by adjusting the privacy setting. The law still helps to protect the data privacy concern. Now, I will be discussing with you the adverse effect. What are the adverse effects? First is habeas data collection. There are worries about the erosion of privacy due to widespread collecting of personal data, frequently without clear user agreement. People create enormous volume of data from their daily interaction with smart gadgets and their online activities, which can be used for a variety of purposes. Next is surveillance and intrusion. The use of sophisticated surveillance technologies such as facial recognition and predictive analytics raises the possibility of uninvited personal invasion. This goes beyond the public sphere, permitting private areas and upending conventional ideas of individual liberty. Next problem is algorithmic discrimination and bias. Artificial intelligence, which is powered by machine learning algorithms, has the potential to unintentionally reinforce prejudices, resulting in discriminatory practice in the banking, law enforcement and employment sectors. These algorithms' opacity heightens question about responsibility and justice. The next problem is data breach and cybersecurity risk. People are more vulnerable to identity theft and financial fraud due to the growing frequency and scope of data breaches. Strong cybersecurity safeguards are increasingly necessary as thieves find personal information to be a profitable target. The next issue is difficulties with regulation and enforcement. Developing comprehensive regulatory framework is often not kept up with the rapid advancement of technology. Due to this delay, it becomes more difficult to enforce privacy law, giving people few options for redressal when their rights are violated. Now, I will be discussing need for data privacy law in the digital era. We cannot deny anymore that we live in a digital age where everything is on our screens. From our data to our currency, from movie and songs to shopping, every domain has been digitized. In such a digitalized world, information proves to be significant. As a result, the perils to our data privacy have increased multifold. India is an economy that is growing spontaneously, and with that growth, the importance of our sensitive data has also been recognized. The need for data protection and privacy law can be summarized as follows. First is provides for protection of personal and non-personal information of people. The data privacy laws are aimed at ensuring proper protection and security of the personal and non-personal information of the citizens. These laws regulate how the information is collected and processed, the grounds of consent of the individual, penalties in case the companies do not protect the data as required by law, etc. Second is builds stronger trust and confidence. These laws are also vital as they build a stronger foundation for trust and confidence amongst the people. When companies prioritize privacy of their users' data and use their data scrupulously, it showcases their commitment to protecting their personal data, which in turn helps the consumer build a better and stronger relationship with the concerned company. Next point is preserve right to privacy. The Indian Constitution acknowledges the right to privacy of an individual as a fundamental right. This implies that every individual has a right to their own data. It allows them to decide how they want their data to be used and when they want to withdraw their consent or object to their processing of their data. Next is increased digital footprints. India has a population of more than 1 billion people, and it is no surprise that a significant part of the population is now connected to the internet. With the extensive use of social media such as YouTube, Instagram, TikTok, etc., people are leaving behind digital footprints all over the internet. If not handled correctly, this invites major digital data breaches where our personal data and history may be made public. Next point is lack of awareness. The sheer lack of understanding of data privacy in our nation also becomes another reason to bring up such a law. People use the internet all the time, but they do not really understand the law behind it. They are unable to comprehend the consequences of their action at the time. Once such a law is in place, there will be more awareness about the importance of privacy on digital platform, and it will be easier to educate people about their rights and obligations while they are active on digital platform. Next point is prevent the data breaches, identity theft, etc. With increasing number of people who have joined the digitization process, there are higher chance of any offence being committed such as fraud, identity theft, data breaches, etc. The data privacy law plays a crucial role in putting such mechanism in place that would help to prevent these offences. Next point is promotes innovation and economic growth. A country with properly regulated data protection laws can promote a legal framework that balances the individual's right to privacy with digital growth. With newer companies finding a place, data privacy will also find its pending significance. More nations and companies will consider investing in our companies if their data protecting framework is strong. Maintaining the children's privacy. Children as well have become more active on all digital platforms, due to which the need for special law and provisions to ensure the protection of their data is needed. The issues concerning their consent and their rights need special attention, as they are quite different from the normal cases of data collection. A lot of games collect diverse personal information about kids easily in order for them to play their game, and kids are unaware of ramification of the same. A proper law in place would make sure that not only such data is protected, but also that there is more awareness about it. Next point is data ethics. These laws not only serve the purpose of data processing and collecting, but also data ethics. The data ethics are the principle that ensure that data collection and strong processing are all based on ethical standard. There is fair and transparent data processing, and the processing is non-arbitrary and non-discriminatory. Right of the individuals. The data protection laws empower the individual in more than just one way. They get a right to know about their data, its collection, storage and transfer, and also get a right of redressal in case of any violation. They are properly compensated for any data breach. It sets up an effective grievance redressal mechanism and make people aware of the right they possess in relation to their data. Now, I will be discussing with you current techno-legal protection. Now, right to privacy is a fundamental right and an intrinsic part of Article 21 that protects life and liberty of the citizens, and as a part of freedoms guaranteed by Part 3 of the Constitution. This landmark decision was held in Justice K.S. Puttaswamy versus Union of India, led by a 9-judge bench on 24th August 2017, by giving a verdict affirming that the Constitution of India guarantees to each individual a fundamental right to privacy. However, India has not yet enacted any specific legislation on data protection. The primary enactment which deals with protection of data are Information Technology Act 2000 and Information Technology Reasonable Security Practice Rule 2011. These are also known as IT rules. The IT rules imposed additional requirements on commercial and business entities in India relating to the collection and disclosure of sensitive personal data or information. It included various new rules that required companies and organizations which process personal information to obtain data owners' written consent before undertaking certain activities. Previously, the IT Act 2000 had undergone certain changes which were introduced by Information Technology Amendment Act of 2008 and added section 43(8) and 72(a) to the Act. Section 43(a) deals with implementation of reasonable security practice for sensitive personal data or information and provides for the compensation of the person affected by wrongful loss or wrongful gain. The sensitive personal data or information as referred in the provisions include passwords, financial information, physical, psychological and mental health conditions, sexual orientation, medical records and history, biometric information. Section 72(a) provides for imprisonment for a period up to 3 years and or a fine up to rupees 5 lakh for a person who causes wrongful loss or wrongful gain by disclosing personal information of another person while providing services under the terms of lawful contract. Under Rule 5 of the IT Rules 2011, any body, corporate or person on its behalf shall not collect any personal data or information unless it is collected for a legal purpose concerning any functional activity of the body corporate, and that collection of such information is necessary for that purpose. Further, the person whose information is shared must be made aware of the fact that the information is being collected, the purpose behind it, the intended recipient of such information, the name and other details of the agency collecting the information and the agency retaining the information. Any corporate body or person holding the personal information of the data subjects cannot retain it longer than the period of its lawful requirement, and also cannot be used for purpose other than for which it was collected. The provider of the information has the option to give or not to give his consent for data collection, and can even withdraw his earlier given consent at any time. The consent is required even for the purpose of sharing information with the third party. However, no such consent from the information provider is required where the information is shared with government agencies mandated under the law to obtain information including sensitive personal data or information for the purpose of verification of identity or for prevention, detection, investigation including cyber incidents, prosecution and punishment of offences. However, these regulations deal only with a corporate body collecting and disseminating data. The information freely available in the public domain is not considered within the scope of sensitive personal data or information. The Indian legal system lacks a comprehensive legislation to regulate the collection and dissemination of personal data. There are no specific regulations which govern the processing of personal data, which is not per se sensitive personal data or information. Now, coming to Digital Personal Data Protection Act of 2003. The DPDP Act is a recent piece of legislation for processing of personal data in India. It was finally adopted almost 6 years after the Supreme Court recognized the fundamental right to privacy in Article 21. The DPDP Act is framed against the backdrop of privacy laws around the world, like the European Union's GDPR, and thus deals with privacy and protection obligations concerning personal data. It is considered that DPDP Act borrows some concept directly from GDPR and has a wide range of applicability extending outside the territory. While on one hand the Act imposes a stringent obligation for unlawful processing of personal data, on the other hand there are significant exceptions for governmental bodies. The Data Protection Act established a comprehensive framework for the processing of personal data and has replaced the limited provisions of the IT Act. Here are some important aspects of Data Protection Act. Body formed under the Act. The Act uses various terms which can look confusing on the outset. It is important to understand the difference between the term used like data processors, data fiduciaries, data principals, data controllers, etc. The person whose personal data is collected is called data principal. The fiduciary is the body that determines the purpose and means behind processing of personal data. Their position is equivalent to that of a data controller. Exceptions allowed under the Data Protection Act. Exceptions in the interest of sovereignty and integrity of India, security of state, friendly relation with foreign state, maintenance of public order and preventing incitement to commit offences are allowed under DPDP Act. Applicability of the Act. The Act has extraterritorial application and has no restriction on international data transfers. Ground for lawful processing of data. Consent is primary source for lawful processing of data. Also, data fiduciaries can identify a legitimate claim for lawful processing of data. Data subject rights and obligations. There are rights for the data principals like the right to access, right to erasure and the right to object, and then there are also obligation non-compliance of which leads to fines and punishment. Concluding the topic. In conclusion, I can say that the right to privacy is a fundamental right. It is a right which protects the inner sphere of individual from interference from both state and non-state actors and allow the individual to make autonomous life choices. It is rightly expressed that the technology has made it possible to enter a citizen's house without knocking at his or her door, and this is equally possible both by the state and non-state actors. It is an individual choice as to who enters his house, now he lives and in what relationship. The privacy of the home must protect the family, marriage, procreation and sexual orientation, which are all important aspects of dignity. If the individual permits someone to enter the house, it does not mean that others can enter the house. The only check and balance is that it should not harm the other individual or affect his or her rights. This applies both to the physical form and to the technology. In an era where there are wide, varied social and cultural norms, and more so in a country like ours which prides itself on its diversity, privacy is one of the most important rights to be protected both against state and non-state actors and be recognized as a fundamental right. The legislature should take the required measure to ensure that the privacy of its citizens is not violated. There are only few things such as national security etc., which surpass the value of individual privacy and thus justifies the concept that privacy is not an absolute right and is under some reasonable restrictions. The advanced technology demands more advanced law, and it is hoped that the pending Personal Data Protection Act will cover the existing gap between the technology and the legal system. I hope the lecture is useful for you. Thank you and have a nice day.